welcome you to this MOOC lecture on National Legal Services Authorities Act and Right to Free Legal Aid. In a country like India, when we have a vast chunk of population suffering from poverty, do not have proper education, and access to legal services is a serious challenge, and we find very often the justice delayed and people are not having access to the justice. So, this right to free legal aid has emerged as an act slowly by the constitutional provisions, and we find the government of India has come up with various measures to ensure the people of the country with a legal service. So, in this context, we find that the National Legal Services Authorities Act has come up, and with very other provisions, it has come to provide this legal service. Now, before we go to this discussion on what are the different steps taken by the government of India, let us first understand what is the legal aid service. So, by free legal aid, we can say it is the provision of free legal services in civil and criminal matters for those poor and marginalized sections of the society who cannot afford the services of a lawyer for the conduct of a case or a legal proceeding in any court, tribunal or authority. These services are governed by Legal Services Authorities Act, which came up in 1987 and headed by the National Legal Service Authority, which was established in 1995. So now, according to the section 2C of the Legal Services Authorities Act, legal services includes any service in the conduct of any case or other legal proceeding before any court or other authority or tribunal, and the giving of advice on any legal matter. Free legal aid is not confined to the cases in the lower courts only. Rather, we find it is also applicable for the higher courts. Now, it is the free legal aid councils who actually provide the service to the needy people either in lower court or at high court or to the highest, that is the Supreme Court of India. Right to free legal aid is a fundamental right, and it can be explained from the various constitutional provisions we have. And in fact, with these constitutional provisions, we have the landmark judgments on legal aid services have come up on the basis of these provisions. So, what are those provisions? Now, the right to free legal aid, if we go through by this Article 21, that is what says that right to life and personal liberty. So, it is provided under this Article 21 that no person shall be deprived of his right to life and personal liberty except according to the procedure established by the law. So, this is what Article 21 says. Then, if you go by Articles 14 and 22 of the Constitution, which makes it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. The Article 39A says that the state shall secure operation of the legal system and promote justice on a basis of equal opportunity, and shall in particular provide free legal services by suitable legislation or schemes or in any other form to ensure the opportunities for securing justice are not that denied to any citizen by reason of economic or other disabilities. So, these constitutional provisions helps to establish the right to free legal aid as a fundamental right. Now, why this free legal aid? We have already discussed that, the poverty level of the country and the educational level. If you see, there is a decline of, or there is, rather, you can say, low performance of educational, you can say, education itself. When we see the first one, we see the literacy ratio, then we see the gross enrollment at school level, primary school level, high school level, then the higher educational level. There is a gradual drop of the percentage, you can see slowly, and people do not have much knowledge about the different affairs that go around them. So they are not very much capable to understand the very procedure of the legal services, first of all, and secondly, the economic condition. What we know that India is a developing country, and the population is a the very populous country, most populous country of the world now. So people are, there is a significant percentage of people, say around roughly I can say 20%, according to the recent data, who are below the poverty line, and we can understand that for them having access to legal services is very difficult, as it is very cost effective. So it is the National Legal Services Authorities Act which has come up, and which has, along with other provisions, other changes, it has tried, or it is trying to ensure legal justice to the people of the country. We need to discuss about a bit about how it has come up, the historical background before right to free legal aid. So the process is not very smooth one, and it started long back, we can say since 1952, when the government of India started addressing the question of legal aid for the poor in various conferences of law ministers and law commissions. And in 1960, some guidelines were drawn by the government for legal aid schemes. In different states, legal aid schemes were floated through legal aid boards, societies, and law departments. In 1980, a committee at the national level was constituted to oversee and supervise the legal aid programs throughout the country under the chairmanship of Justice P.N. Bhagavati, the then judge of Supreme Court. This committee came to be known as CILAS, that is Committee for Implementing Legal Aid Schemes, and started monitoring legal aid activities throughout the country. And we find slowly there are some other provisions for legal aids, and a very significant growth in this, or development in this regard, is the emergence of Lok Adalats, which added a new chapter to the justice dispensation system of this country, and succeeded in providing a supplementary forum to the litigants for conciliatory settlement of their disputes. In 1987, the National Legal Aids, rather I will say Legal Services Authorities Act was passed, and passed to give a statutory base to legal aid programs throughout the country on a uniform pattern. This act was enforced in 1995 after its amendment in 1994. We can see some relevant provisions in our constitutional law, which also helped in the growth of these free legal aid services in the country. These are the Order 33 of the Code of Civil Procedure 1908, Section 304 of the Criminal Procedure Code 1973, then the Legal Services Authority Act, which already we have discussed, and then National Legal Services Authority Rule 1995, then High Court Legal Services Committee Regulations 1998, the Legal Services Authorities Act 2002, The National Legal Services Authority Free and Competent Legal Services Regulations 2010 and the National Legal Services Authorities Legal Aid Clinics Regulations 2009. So these are certain steps taken up by the government for the easy service of the legal aid. As we know that in the process, the most crucial juncture of the service of free legal aid is the development of the National Legal Services Authority. So this is the kind of organization which came up, or as well as an institution which came up to supervise, monitor, and also to develop mechanism to provide services, legal aid services. And its organizational structure includes, one is at the state level, of course, one central level, that is national level, then state level, then district level, then taluka level, so that at each level people can have access to legal aid services. So if we go through this growth of this free legal aid service, we find a number of judgments were very crucial and which actually implemented or brought out this service of legal service slowly. So these are those judgments which have applied the Article 39A, then 21, and slowly they have incorporated the provisions laid therein in the judgments. One very important judgment or landmark judgment in this context is the Husainara Khatun versus Home Secretary, State of Bihar. So in this judgment, what we have seen is that the prisoners had to suffer more time because of the delay in the procedure. So it is then the judgment then says that it is the duty of the government to provide legal services so that they get a justice. So it was argued that most of the prisoners in Bihar had to undergo excess punishment due to lack of legal representation. So they didn't have legal representation and they had to suffer from excess punishment, and there was a procedural delays. So the apex court had thus pointed out that the Article 39A made free legal services an inalienable element of the unreasonable activities, and mainly for the reasonable and fair and just procedural implied in Article 21 of the Constitution. So that way we find another judgment, that is judgment Khatri versus State of Bihar, where the state reiterated the principle that free legal aid is an essential element of Article 21, and it is opined that it is the state's duty to provide a lawyer to the accused if the circumstances require so. Same is the case with Madhav Hayavadan Rao Hoskot versus State of Maharashtra, where the court says that in case of in this case, court says that the right to counsel principle should be applied in this context, because it held that the right to appeal is an integral part of the reasonable and fair procedure under Article 21. So if you go through all these, if you go through this Sila versus State of Maharashtra, then Muhammad Ajmal Muhammad Amir Kasab versus others and State of Maharashtra, then Raju at Ramakant versus State of Madhya Pradesh, and Sukdas versus Union Territory of Arunachal Pradesh, and many more like this. All these have actually tried to take the plea from this our constitutional provisions of Article 39A and 21 to establish that how the common people, the needy people, should have access to free legal aid. Now, And slowly we find that this free legal aid has come up as a must legal service by the government with the establishment of the National Legal Services Authority. Now, what are these free legal aids? What are those aids that should be provided to the needy people? So, the provision says that it can be in the form of a representation. Obviously, the first should be the representation by an advocate in legal proceedings, then the payment of process fees. Because in legal services, legal actions, in the procedure, there is a fees which is very much required. So, that legal fees should be paid by the by the state itself. So, payment of process fees, expenses of witnesses and all other charges payable or incurred in connection with any legal proceedings in appropriate cases. Then preparation of pleadings, memo of appeal, paper book, including printing and translation of documents of legal proceedings. Then drafting or legal documents, special leave petitions, etc., and also the supply of certified copies of judgments, orders, notes of evidence and other documents in legal proceedings. So, these are certain legal aids which should be provided to the needy people which were brought under this National Legal Service Authorities Act. Next comes is the eligibility. Who are the eligible people? Who can have the access to free legal aid? So, again this is also very much reflected in the provisions made. The free legal aid is provided to weaker sections of the society who fall within the purview of section 12 of the Legal Services Authorities Act 1987. So, who are those people? Obviously, when we talk about weaker sections, it is the scheduled castes, scheduled tribes, and then a victim of trafficking in human beings or beggar, as referred to Article 23 of the Constitution, a woman or a child, then a mentally ill or otherwise disabled person, a person with which we call as a differentially challenged or differentially able person. Then a person under circumstances of undeserved want, such as being a victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or other natural calamities. Then an industrial workman is also an eligible person, or in custody, including custody in a protective home within the meaning of clause G of section 2 of the Immoral Traffic Prevention Act 1956. Then also those who are in a psychiatric hospital or psychiatric nursing home within the meaning of clause G of the section 2 of the Mental Health 1987, the procedures. So, thus there is a special provision for providing access to legal aid to victims of trafficking as well as women and children. There are also provisions we have seen the eligibility for which a person can have a free legal aid. But at the same time, we also have certain provisions or certain conditions which make people which make that they should be withdrawn to have access to free legal aid. If they are even taking any free legal aid, they will be also they will not be able to take or exercise it further if certain things are observed. So, who are those, and in which case this legal aid can be denied or withdrawn? So, this is a legal aid we find can be denied at the initial stage before the application for legal aid is accepted. It can also be withdrawn at the later stage after the application has been accepted and legal aid has been provided. So, at any time it can be denied if the case is found unsuitable for providing legal aid. So, what are those situations? A legal aid can be denied if a person is found ineligible under Section 12 of the Legal Services Authorities Act 1987. Legal aid can be withdrawn if the aided person who applied under the income category is found possessing sufficient means to avail or to pay for the legal aid services. So legal services, so they will not be allowed to get the access to free legal services. Then legal aid can also be withdrawn where the aided person obtained legal services by representation or fraud. Obviously, when there is a representation, misrepresentation and fraud, in that case the legal aid services, free legal aid services which were being provided will be stopped or withdrawn immediately. Legal aid can be withdrawn where the aided person does not cooperate with the legal services authority or committee or with the legal services advocate. So there the beneficiary has to cooperate with the authority, then only it can be provided. So when someone is not cooperating, so it can also be withdrawn. So these are certain things. Then we also find again it can be withdrawn where the person engages a legal practitioner other than one assigned by the legal services. So the person, the beneficiary, when he will be assigning another legal practitioner along with the paneled counsels, then also it will be withdrawn. Then again, if the application for legal service or the matter in question is found to be an abuse of the process of law or of legal services. So these are certain cases where legal services, even if provided at the initial level or even in the mid of the services, can be withdrawn from the beneficiary. So what we find is that till now there is a sufficient move to provide justice to the people in terms of services, in terms of legal services as an aid and free aid to the people, needy people, and so that constitution and or people can be portrayed as equal in front of law, in the eye of law. So this is how legal services has been authorities, legal services authority has come up, and many other provisions have tried to provide free legal aids. There are many other initiatives taken by Government of India, like we have come across Nyaya Bandhu concept, then Nyaya Mitra concept. Then there are some online deliveries so that certain cases can be resolved online by taking the court to the villages or to the talukas and all. So these are certain initiatives being taken. But now question is that how far how far these objectives could be met, how far the state is successful in achieving providing free legal services. A number of criticisms are found, and a number of studies have been conducted to see the implementation of the free legal aid services and the success or achievement of these free legal aids as is provision by the constitution as well as by as is instituted with different acts and statutes by our Government of India. So we'll discuss the next step. The next step tries to deal with these situations or to see the state of the art of the free legal aids aid services to the people. Till now we have observed, we have discussed the emergence of the free legal aid services in India, the institution of National Legal Services Authority, and the different provisions, and also we have discussed about different landmark judgments which became instrumental in the growth of free legal services in India. Now question comes, how far we could avail or could attain our success in this regard. How far this free legal aid service is enjoyed by the people of the country. If you go through the studies and the newspaper reports and all, very often we come across with dissatisfaction with the services due to many reasons. Even if we go through the research works, the books written are written, this focus on the drawbacks in our system and the lack of achieving the goal in this regard. Most often what is observed is that the empaneled lawyers who are known as legal aid counsel, they are not being trusted by the people for two reasons. One is the quality of their service. Secondly, the trust. I mean, somehow there is a lack of trust on those counsels to have access to free legal aid. Even there are studies even some reports which say that women prefer to go for paying for, even if they are suffering, they go for taking paid services than the free legal aids. So, these major landmark studies or works in this regard, one book is there by Justice S. Muralidhar. The name of the book is Law, Poverty and Legal Aid, Access to Criminal Justice. So, in that book, he has discussed how this the funds are being utilized for administrative purposes and not for legal aid. There are reports which say that legal counsels are not paid. So, they prefer, as is reported by India Spanned, they have taken interviews of those counsels who have stopped serving further, who were serving as legal aid counsels. The number of studies reflect on the similar problems with these legal aid services. Tata, again, if we go through some of the reports as like Tata Trust India Justice Report 2020, or even if you go through this Commonwealth Human Rights Initiative, we find that they are of the view that the expenditure on free legal aid services or mainly legal aids for legal services by Government of India is too meager in comparison to the rest of the countries of the world. And as it is said that Commonwealth Human Rights Initiative, it says that around there are 5 legal aid councils for 1 lakh population. So, obviously, if we see the population or the number of beneficiary and the number of existing councils, it is almost very negligible, almost equal to no, because one council cannot handle 20,000 people. So, this is the findings which also reflects the problem with our legal aid system. Reflect the problems if we go through all these studies. Besides, we have to also look at another side, that even if we have the service available, there is another side where we have people who are not aware of this of these services. They do not have any legal education or awareness for which they can avail these. So, it takes time to educate them or to make them aware. So, these are other dimensions. They are poor, they are not able to even come across or come out of their setting to raise issues, because they are more busy in their struggle of existence, struggle for life. So, they are not having access, or they are not having the capacity, you can say, to come forward and to avail these services. So, it's not that if we see the donors as well as receivers, both the sides, we found that there are serious problems which are to be addressed by our by the stakeholders to come out of to come with a solution to have a better legal aids. There are recommendations by different studies we have seen, there is a necessity of awareness, though we know that government also has provisions for arranging awareness programs. But then still, I think it is too meager. And we need to focus more on making people aware about this legal aids services and availability of these provisions so that they can have access to these services. Then we need to also look forward to change the system of even if the problems of operation of National Legal Services Authority, as in many cases it is reported that they are not serving, they are not following. In many cases, the guidelines are being not followed by by these officials. So this is another problem. Like there is a provision of recording the witnesses and many others which are not being maintained by, as is reported by many studies. So these are to be ensured. Otherwise, the very aim will not be successful if we are not following the provisions in toto. Then there is also reports and problems, as has been reported, that there is a handicap with certain regulators of these legal aid councils. So they also need more power so that they can take certain steps to punish the non-performers, mainly the councils, legal aid councils. They should be punished in whatever form, but there is a necessity of controlling that side also. So the problem is not simply simply lying with the government or with the beneficiary. We find the problem everywhere, and we need to intervene at multi-level to come up with a better legal service and to ensure justice for all, justice to all. Thank you.